Welcome to the Deep Dive. Today we're jumping into a really challenging idea, one that cuts against how many of us think about the Supreme Court.
Yeah, it's definitely provocative.
The basic idea is this. What if the Supreme Court isn't just interpreting the Constitution, but actively rewriting it, acting like a continuous constitutional convention, changing our fundamental law without asking us, the people?
And that's precisely the core argument in Raoul Berger's huge work, Government by Judiciary. His claim, really, is that the court fundamentally twisted the 14th Amendment.
The 14A.
Exactly, the 14A. He says they took something meant for a very specific, limited purpose and turned it into this open-ended tool for judges to make policy. He basically argues they grabbed powers they were never meant to have, sidelining the democratic process.
Okay, so that's the charge. And our mission for this deep dive is to explore that. We're going to look at the actual history, the records from the 39th Congress, the people who wrote the 14A back in 1866.
We need to figure out what they intended, what the original scope was supposed to be.
Right, because only then can we really compare it to how the court has used it later on. Thinking about huge cases like, say, Brown v. Board of Education or the one man, one vote stuff.
And it's crucial to understand this isn't just some dusty historical debate for Berger. His whole point is about defending self-government.
Also,
he argues that sticking to the framers' original intent is essential for the rule of law. When judges start putting their own policy ideas above the text, well, that's not judging anymore. It's ruling by decree. Judicial fiat, he calls it. The big question becomes, who actually gets to change the Constitution?
Okay, let's dig into that first big claim then. This idea of the court as a continuous constitutional convention. It sounds pretty radical.
It is, especially if you see the court as, the ultimate guardian. But Berger argues they're constantly adapting or updating the Constitution through interpretation.
Instead of using the official way, Article V.
Exactly. Instead of the amendment process laid out in Article V, which is deliberately difficult. And it's interesting, other scholars, like Beck and Levy, have actually used that same phrase, continuous constitutional convention. Sometimes maybe as a sort of polite way of saying the court is rewriting things.
And this isn't just a recent complaint, right? This goes way back.
Oh, absolutely. You see this criticism leveled even when the court was pushing a totally different ideology. Think pre-1937.
A Lochner era.
Right. Robert H. Jackson, who is Solicitor General and later a justice himself, he had this scathing critique. He said the court back then sat almost as a continuous constitutional convention which, without submitting its proposals to any ratification or rejection, could amend the basic law.
And they were using the due process clause then to strike down economic regulations, labor laws.
Yeah, reading laissez-faire economics into the Constitution. So the mechanism judges rewriting the rules was the same, even if the political goal was different from later courts.
That's a key point. The process is the issue for Berger, not necessarily the specific outcome.
Precisely. And you even see glimpses of recognition from people who might have agreed with later decisions, like Archibald Cox, when the big reapportionment cases came down. Someone apparently asked him if he felt like he was at a second American constitutional convention.
And what did he say?
He reportedly said, "It feels awful." That gut reaction tells you something, right? An awareness, maybe, that the court was overstepping, moving from law into, fundamental political restructuring.
So Berger sees two big shifts in this kind of activism.
That's right. He wants to show the mechanism is the constant problem. Before 1937, you had the court using due process to block economic reforms, what they saw as socialism. Justice Holmes famously quipped they'd discovered new principles reflecting old economic theories.
Right. Substantive due process basically meant protecting property rights above all else.
For decades, yes. But then, after 1937, the court kind of flips. It backs off the economic stuff, but embraces what some called a new faith libertarianism, focusing on individual rights, civil rights.
But using the same tools, the same clauses, like due process.
Exactly the same tools, just pointed in a different direction. Berger argues that the justification for using, say, the due process clause for this new set of policies is actually even shakier, historically speaking, than the old economic activism was.
And this connects to what the scholar Louis Liskey pointed out.
Yes. Liskey, who actually supported some of the Warren Court's results, still identified the two critical shifts that enable this kind of judicial power. First, the court basically claims the power to revise the Constitution, bypassing Article V.
Bypassing the people, essentially.
Right. And second, they quietly ditch the original limits on judicial review that were established way back in Marbury v. Madison.
So if the court is revising the Constitution, acting like a convention, that's a huge departure from its original job description. What was that original role supposed to be?
Well, the founders were actually pretty clear about keeping the judiciary out of policymaking. The big debate over the Council of Revision shows this.
What was that?
It was a proposal to have judges involved in reviewing and vetoing legislation before it became law, but the Constitutional Convention rejected it. Why? Because they felt that function was quite foreign from the nature of the office. A judge's job wasn't supposed to be political vetting.
And Hamilton drives this home in the Federalist Papers, doesn't he?
He really does. Famously, he says the judiciary can take no active resolution whatever. It has, quote, neither force nor will, but merely judgment.
So its job is just to judge, to apply the law.
And police the boundaries. To stop Congress or the president from encroachments, from stepping outside the lines drawn by the Constitution, but definitely not to initiate policy or drive social change. That whole idea, judicial activism as we know it, was just alien back then. Judicial innovation was seen as an impermissible exercise of will.
Okay, so a strictly limited judicial role was the plan. How then did one amendment, the 14th, become the vehicle for such massive judicial power later on? We need to go back to 1866, the 39th Congress. What was the atmosphere like then, especially regarding race?
Yeah, we have to be really honest about this period. It wasn't some golden age of racial enlightenment, even in the North. The historical sources Berger uses talk about deep and ugly fears and almost ineradicable prejudice against Black people pretty much everywhere.
Even among Republicans who had fought slavery.
Yes. Figures like George Julian, a radical Republican, admitted the proverbial hatred Northerners felt. Senator Lane spoke of that almost ineradicable prejudice. You had states in the North that still had segregated schools, that had recently voted against giving Black men the vote.
Indiana's Constitution even barred Black people from entering the state, right?
Right, the 1851 Constitution. So this is the backdrop. You can't understand the 14A or the Civil Rights Act of 1866 without understanding this pervasive racism.
So what was the purpose then, if not broad equality?
It wasn't about implementing some grand abolitionist dream of total equality. It was much more pragmatic, more political. As historian Keller put it, the goal was really about securing some minimal protections for the newly freed slaves in the South.
Minimal protections, like what?
And ensuring they could function as a stable labor force. So basic legal rights to keep society running down there.
Okay, so if it wasn't this grand vision, what specifically did the 14A aim to do? You said constitutionalize the Civil Rights Act.
That was its primary job, to take the specific, limited rights laid out in the 1866 Civil Rights Act and anchor them in the Constitution so a later Congress couldn't just repeal them.
And what were those rights? The act focused on civil rights, but what did that mean back then?
It meant the traditional common law rights, often summed up by Blackstone's triad.
Which is?
Personal security, the right to life, basically. Personal liberty, freedom to move around, make contracts, not be locked up arbitrarily. And property, the right to own and inherit property.
And the framers knew this limited definition.
Oh, absolutely. James Wilson, who was the chairman of the House Judiciary Committee, a key player, he literally read Blackstone's list to Congress during the debates. He made it clear these were the fundamental rights they were talking about.
So the goal was practical. Stop the southern states from using those black codes to basically re-enslave people through the legal system.
Exactly. Ensure Black citizens had the basic legal capacity to live, work, make contracts, sue if they needed to, own a piece of land. Just the fundamentals of participating in civil society, not political rights, not social equality.
Which brings us to what Berger argues was explicitly excluded. He says the framers deliberately kept two huge issues out of the 14A, voting rights and segregation. Let's take suffrage first.
Yeah, suffrage was absolutely undeniably off the table. The Republicans in Congress knew they couldn't force Negro suffrage on the northern states, let alone the southern ones. It was politically toxic.
And the key figure said so.
Explicitly. Senator Trumbull, who drafted the Civil Rights Act, stated point blank, a bill deals exclusively to civil rights. It does not propose to regulate political rights. It has nothing to do with the right of suffrage. Couldn't be clearer.
Yeah, and Bingham, who was central to drafting Section 1 of the 14A,
Same thing. Bingham said, the amendment does not give the power of regulating suffrage in the several states. They consciously left voting rules to the individual states.
And doesn't Section 2 of the 14A itself prove this?
It's the clincher, really. Section 2 says that if a state denies the vote to any qualified male citizens, its representation in Congress will be reduced proportionally.
Which only makes sense if Section 1 didn't grant voting rights automatically.
Precisely. If Section 1 gave everyone the vote, Section 2 would be meaningless. It confirms they knew states could and would deny suffrage, and this was the agreed-upon remedy: reduced power in Washington, not a federal takeover of voting.
Okay, so political rights, like voting and apportionment, were left to the states. What about segregation, the issue at the heart of Brown v. Board?
The historical record, Berger argues, is just as definitive here. The framers intended to leave segregation laws, things like separate schools, exactly as they were, meaning under state control.
Did they talk about schools specifically?
Yes. James Wilson, the same Judiciary chairman, explicitly denied that civil rights meant that black and white children shall attend the same schools. Given the segregated schools in many northern states at the time, the idea that they were secretly mandating integration nationwide is just not historically plausible.
And this wasn't just Berger's conclusion. Didn't Alexander Bickel find the same thing when he researched it for Justice Frankfurter?
That's a fascinating story. Bickel, clerking for Frankfurter while Brown was being debated, did a deep dive into the 14A's legislative history. His conclusion, in a memo to the justice, was stark. It was impossible to conclude that the 39th Congress intended that segregation be abolished.
Impossible.
That was his word, impossible.
Yeah.
And also impossible to think they even foresaw it might be abolished using the language they adopted. The history showed they just didn't touch the issue of school segregation. It remained a state matter.
So if the framers had wanted the 14A to be this engine for future change, this sort of blank check for equality that some argue it is, they could have used much broader language.
They absolutely could have. And crucially, they considered it and rejected it.
How so?
Well, Thaddeus Stevens, one of the most radical Republicans, proposed language that really was sweeping. He wanted to say, all laws, state or federal, shall operate impartially and equally on all persons without regard to race or color.
That sounds much closer to what the court eventually did.
It does. It likely would have outlawed segregation and maybe much more. But what happened to Stevens' proposal?
It was voted down?
Voted down decisively, 38-7. That vote is powerful evidence of the majority's limited intent. They specifically chose not to adopt that kind of broad equality mandating language.
Were there other examples of rejecting broad language?
Yes. During the debate on the Civil Rights Act, the phrase, "there shall be no discrimination in civil rights," was actually deleted. James Wilson explained it was to prevent a latitudinarian or overly broad interpretation. They were deliberately trying to keep the scope narrow and defined. Senator Fessenden summed up the political reality bluntly. We cannot put into the Constitution, owing to existing prejudices and existing institutions, an entire exclusion of all class distinctions.
So the historical record seems pretty strongly against this idea that they intended to give future courts a free hand.
Berger's argument is that the evidence is overwhelming. They intended something specific and limited, and they rejected language that would have done more.
Okay, so if the original intent was so limited, how did the court eventually use the 14A to make such huge policy changes? You mentioned they used vague terms.
Right. Berger argues the court seized on two phrases, what he calls magistic generalities, and basically poured new meaning into them: due process of law and equal protection of the laws.
Let's start with due process. You said earlier it was originally just procedural.
Absolutely. Its history goes back centuries to Magna Carta. In 1866, any lawyer would have understood due process to mean established legal procedures, fair notice, a hearing, proper indictment, things related to how the law was applied in court. It was about the process.
Not about the fairness of the law itself.
Correct. It was procedural, not substantive. As Berger puts it, the meaning was fixed and definite as the common law could make a phrase. It was about things like fair trials.
But the court turned it into substantive due process. What does that mean?
It means the court started using the due process clause to review the substance, the content of the law itself, to ask, is this law reasonable? Is it arbitrary? Does it violate some fundamental right not explicitly listed elsewhere?
Which allows judges to strike down laws they just don't like.
That's the danger, yes. It transforms the clause from a shield ensuring fair procedure into a potential sword for judges to impose their own views on what constitutes good or bad policy. This shift started way back, maybe with cases like Weinhammer in 1856, initially to protect property rights.
The Lochner-era stuff again.
Exactly. But the key is the transformation of the clause's meaning, which then got used later for different kinds of rights. Berger argues this was a judicial invention, pure and simple.
What about the idea that the 14A incorporated the Bill of Rights, applying Amendments 1 through 8 to the states? Justice Black was a big proponent of that.
Yeah, the Incorporation doctrine. That's another major way the 14A's scope was expanded. But Berger argues the history really doesn't support it.
How so? Didn't Senator Howard suggest it?
He did mention incorporating the first 8 amendments during a long speech explaining the proposed 14A. But Berger points out it was kind of casually tucked in, wasn't really debated or challenged, and right after Howard spoke, others immediately went back to emphasizing the main limited goal, constitutionalizing the Civil Rights Act.
Like Senator Poland.
Right. Poland said the Privileges and Immunities Clause, the supposed vehicle for incorporation, secured nothing beyond what was intended by the original provision, meaning Article 4, Section 2, which dealt with interstate citizenship rights. Much narrower.
And if the states thought they were agreeing to apply the entire Bill of Rights against themselves, wouldn't that have been a huge deal during ratification?
You would think so. Imagine states suddenly having to guarantee 12-person juries instead of their traditional 6-person ones, or requiring grand jury indictments for everything. These would be massive, costly changes to their justice systems.
But the debates were silent.
Largely silent on this specific, huge implication. The Supreme Court itself later noted that if such a radical change was intended, it surely would have been expressly declared. That silence is pretty telling. Berger sees incorporation as another post hoc judicial expansion.
Okay, so we have due process being reshaped and incorporation adding the Bill of Rights. This sets the stage for the big cases Berger critiques most heavily: Brown v. Board and the reapportionment decisions.
These are the prime examples for him of the court acting as a policymaker, not a legal interpreter. In Brown, the court ordered desegregation of schools,
Which we just established the framers seemed to leave to the states.
Exactly. And interestingly, Justice Robert Jackson, who was on the court for Brown, wrote an internal memo basically admitting this. He said he couldn't find support for the decision in the history or the traditional legal sources.
But he voted for it anyway.
He did, but he acknowledged the court was essentially declaring new law for a new day. He saw the dilemma.
And Chief Justice Warren's famous line in the Brown opinion:
"We cannot turn back the clock to 1868. Berger reads that as Warren basically saying, yeah, we know the original intent doesn't support this, but we're doing it anyway because times have changed.
So a policy decision dressed up as law.
That's Berger's charge. The court took on the role of legislator, imposing a social policy the country hadn't agreed on through the constitutional amendment process.
Then there's reapportionments, the oh man, one vote rulings.
This, for Berger, is maybe even clearer. These decisions use the Equal Protection Clause of the 14A to force states to redraw their legislative districts based on population equality.
But we already established the framers explicitly excluded political rights like voting and apportionment from the 14A.
Right. They left control over suffrage and how state legislatures were structured entirely to the states. Section 2 confirmed this. So for the court to then use Section 1's Equal Protection Clause to dictate state apportionment,
It's a direct contradiction.
it's a direct contradiction of that original understanding. The court jumped right into the political thicket it was supposed to avoid, regulating a core political right that the 14A was specifically designed not to touch.
Justice Harlan dissented strongly in those cases, didn't he?
He did. He warned the court was substituting its own notions of wise political theory for the Constitution. Berger sees it as a prime example of judicial fiat judges imposing their preferred political structure on the states, ignoring the amendment's history and text.
This really brings us to the core of Berger's project: defending self-government and constitutional fidelity. His critique isn't about the desirability of equality or voting rights, is it?
Not at all. He's not arguing against those values. He's arguing about process, about who gets to decide these things for society. His whole argument rests on the idea that constitutional change must happen through constitutional means.
Which brings us back to original intent. Why sticking to that original understanding so crucial for him?
Because it's what makes the Constitution law. If the meaning can just float free and change whenever 5 judges think it should, then it's not a fixed limit on government power anymore. It's just what the judges say it is. Discarding the framers' intent, for Berger, means discarding the Constitution itself.
And this wasn't just Berger's idea. This was the standard view for a long time.
Oh, yeah. Foundational. James Wilson, back at the founding, said the first and governing maxim of interpretation is finding the meaning of those who made it. You interpret the law based on what the lawmakers intended.
Jefferson said something similar too, right?
He did. Pledged to follow the Constitution according to the safe and honest meaning contemplated by the plain understanding of the people at the time of its adoption. It's about honoring the agreement made by the people.
And the alternative is what? Judges just deciding.
Judicial discretion, which historically was viewed with great suspicion. Blackstone warned about it. He said flawed law is bad, but equity without law, where judges just do what feels right in the moment, is worse because it would make every judge a legislator.
If judges aren't bound by intent, they're just ruling by their private notions, as Berger puts it.
Exactly. They become policymakers, stepping into the role reserved for the people's elected representatives or for the people themselves through the amendment process.
Which is Article V. The Constitution does have a way to change.
It absolutely does. Article V provides the formal amendment process, and the framers deliberately made it hard needing supermajorities in Congress and ratification by 3/4 of the states.
They knew society would change, but they wanted changes to the fundamental law to be difficult, to require broad consensus.
Precisely. People like Patrick Henry and James Iredell acknowledged the difficulty, but accepted it as the price of stability and ensuring changes reflected a truly national will.
So when judges change the meaning of the Constitution through reinterpretation,
they're bypassing Article V. They're bypassing the people. Berger calls this a usurpation, taking a power that belongs solely to the sovereign people. And he insists that just because they've been doing it for a long time doesn't make it legitimate.
And the consequence of this usurpation.
It's the end of the rule of law, he argues. When judges can just substitute their own preferences, their own sense of what's right or wrong for what the Constitution actually requires.
Then it's not law anymore.
It becomes the will of a qadi.
A qadi.
Yeah, like an old Islamic judge who decided cases based on personal expediency or wisdom, not a fixed legal code. In our system, that kind of arbitrary judicial will, disconnected from the text and the people's consent, fundamentally undermines limited government.
So Berger's ultimate argument is a plea to restore the people's authority over the Constitution.
Absolutely. It's a political argument about where power should reside. He'd say pursue liberty, pursue equality, pursue justice, but do it through the means the Constitution provides. Debate, legislation, and when necessary, amendment by the people. Don't let unelected judges make those fundamental choices for us.
Because the integrity of the whole system depends on respecting those limits.
Exactly. The oath officials take is to uphold this Constitution. That requires, Berger insists, exact and constant observance of its principles, including the limits on judicial power. The judiciary serves the law, it doesn't stand above it.
Okay, let's try to wrap up this deep dive into Raoul Berger's challenge. We've seen his core argument. The 14th Amendment wasn't a blank check. It was specific, limited.
Right. Designed to guarantee basic civil rights, life, liberty, property, contract for the freedman. And the historical record shows the framers explicitly rejected applying it to political rights like voting or apportionment or social issues like school segregation. Those were left to the states.
But Berger contends, modern courts took vague phrases like due process and equal protection, ignored or dismissed the original intent.
And essentially turned the amendment into this incredibly powerful tool for judicial policymaking, inventing new rights like substantive due process, incorporating the Bill of Rights in ways the framers likely never imagined.
Which amounts to judges rewriting the Constitution, bypassing the Article V amendment process.
Undermining self-government, substituting judicial will for the consent of the governed. That's the essence of his charge of government by judiciary.
It forces you to really think about where the court gets its legitimacy. If it's not strictly bound by the law it claims to interpret, its authority seems to rest heavily on just public acceptance.
Which can be fragile. And this leads us to that final, really provocative thought, drawing partly on Justice Jackson's observations.
Jackson, who saw it from both sides, as lawyer and judge.
Right. He noted, looking back, that the Supreme Court has often been wrong on most of the outstanding issues upon which it has chosen to challenge the popular branches. So here's the question Berger leaves you with. If the highest court has a history of overreach, of engaging in the very usurpations of power it was meant to prevent, how long can a system based on the rule of law sustain a judiciary that sometimes acts as if it's above that law?
A fundamental challenge indeed.
Well, that's about all the time we have. You've been listening to The Deep Dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shape liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.